I'm Nikki Jovicic from LookUpStrata, and I'm also the Managing Director of Tower Body Corporate, and I'm your host. The New South Wales strata landscape is undergoing significant changes. The Strata Managing Agents Legislation Amendment Bill 2024 will significantly change the way strata managing agents operate in New South Wales. This legislation aims to address growing concerns regarding strata agent practices and enhance transparency and accountability within the industry. We're joined by Kerin from Kerin Benson Lawyers, and the key objective of today's webinar is to break down the changes, explain their implications for both strata managers and lot owners, and guide you on the necessary steps for compliance. Now, this is a New South Wales session, and we're discussing New South Wales legislation. However, if you are joining us from outside of the state of New South Wales, welcome, as these changes may affect eventually updates to legislation in your states. Before we begin, I'd like to mention that the information in this session, including the discussions arising from submitted questions and chat conversations, is not advice and should not be relied upon as advice, and you should seek independent advice before acting on the information contained in the session. Very happy to welcome back Kerin, Legal Practitioner Director at Kerin Benson Lawyers. Christopher has worked as a lawyer for almost 30 years. He worked for many years in leading commercial construction law practices, acting for government, developers and contractors in the building, transport, infrastructure and resources sectors. He's been involved in a whole range of construction projects, from minor works to projects worth billions of dollars. Christopher holds a Masters of Law, is a Law Society of New South Wales accredited specialist in commercial litigation, and has published in a range of law journals and associated publications. He brought his specialist construction industry knowledge to the strata sector and now only acts for owners corporations in New South Wales and ACT. Welcome, Christopher. Thanks so much for joining us again today.
As Nikki indicated, we're talking about the Strata Managing Agents Legislation Amendment Act 2024. Strata agents are basically in positions of power, privilege and confidence. They're gatekeepers to organisations that do spend large amounts of money on goods and services. And there's been, as we know, a lot of publicity in recent months in relation to how some agents have been abusing their position, and to some extent a degree of trust has been lost with the public. This legislation is an effort by the New South Wales government to restore that trust. Just on a personal note, in relation to commissions, I do recall some years ago being approached by a strata manager and being asked to effectively kick back a percentage of fees that I earned from owners corporations referred by them. I flatly refused on the basis that I would have to disclose those payments to the client, and all sorts of questions would arise as to why I was being engaged and so forth. Those of you who've worked in property management will be aware that, property managers, like strata managers, are able to provide some tradies with a good flow of work, and some of the perks that can arise from that are, a new kitchen every 5 or 10 years or so. So unfortunately, I've had some personal experience of this. But the system for strata managers has kind of evolved in a way, kind of by necessity, in some respects. Unfortunately, the management fee for strata managers has not really moved in the last 30 or 40 years. It's still around, depending on where you are and various things, it's still around $100 per unit per quarter. And so strata managers, that's just not keeping pace with inflation and so forth, and the cost of wages. And so strata managers have been forced to kind of find other places to recover revenue. And so some strata managers rely quite heavily on commissions in order to just simply stay afloat. And that's just kind of the way the system has evolved. One of the problems for strata managers is that the barriers to entry into strata management are low. And so there are constantly new people coming into the industry all the time. And it's a standard practice for new entrants to undercut their competitors quite significantly. And that just has an effect of depressing the management fees that can be charged and will be acceptable by the general public. We don't have time to go into all the issues, systemic or otherwise, that affect the business of strata managers, but that kind of gives you a little bit of background. I should say the amendments that we'll be discussing today are building on existing provisions that are already quite onerous, and they're quite onerous because they reflect the fact that at common law, strata managers owe a fiduciary duty to their owners' corporation clients. A fiduciary duty is a duty to act in the best interests of the owners' corporation. It is the highest level of legal relationship that exists. It is the relationship between a strata manager and owners' corporation is the same as the relationship between a solicitor and a client. The key thing is that you must always work in the best interests of your client, even to your own detriment. So that fiduciary duty that is owed by strata managers to owners' corporations is already quite onerous, and the existing provisions, let alone the amendments, are already, as you will see, quite onerous. There are also codes of conduct under the Property and Stock Agents Regulation, which apply to strata managers. So that is already in existence. And interestingly, we have, in the last couple of years in New South Wales, had the situation where the New South Wales SCA has been able to get or enable strata managers to become members of the professional standards scheme. So the professional standards scheme is a scheme that applies to professionals, and it does things like cap liability, provides a kind of stamp of confidence to the public that the person you're talking to is a professional. There are investigative sort of avenues under the scheme and so forth. And so strata managers in New South Wales in the last couple of years have been able to become members of the professional standards scheme and hold themselves out as professionals, just like doctors and engineers and lawyers. And curiously, the investigation that the New South Wales SCA is currently undertaking into the former head of Strata is an investigation under the professional standards scheme. Turning to the legislative amendments and the thinking of the New South Wales government that's given rise to this act, the amendments can be described as a kind of immediate reaction to the Four Corners programs and the Strata scandal. I say that because the debate in New South Wales Parliament has explicitly referred to the Four Corners programs and Strata, and so that's clearly been on the minds of the parliamentarians debating the Act. And it should be noted that the New South Wales government has said, and several times in Parliament, that further reforms will be considered. So this is probably the first of what will be more amendments to be made. We are waiting on the McGrath-Nicol report into the Strata scandal. So McGrath-Nicol are a professional services firm. They've been engaged by the Office of Fair Trading to report on what happened, and we are still waiting for the report. When the Office of Fair Trading receives that report, the New South Wales government has indicated that it may well pass further amendments to governing legislation. So as I said, this is very much the start of what there could be more to come. The focus of these amendments is very much on insurance commissions as opposed to other potential areas of reform or indeed other types of commissions, potentially. There's a new definition of commission, which states commission includes an insurance brokerage fee. So that kind of is the name on the tin and betrays the thrust of the amendments. What I'm trying to do here, the slides are numerous, and for those who are strata managers in New South Wales, the slides, if you go through them, will assist you in distilling what the amendments are and what the current provisions are. And you can use that to look at your internal processes and make amendments where required, because some amendments will be required as a result of these amendments. When facing the issue, the New South Wales government had 4 options, and the options were, firstly, do nothing. That's always an option. But politically, that was really not a viable option. Option 2 was to simply ban commissions outright and the financial benefits as well. The chairperson of the ACCC has come out publicly only like a month ago and called for the banning of insurance commissions. Now, she's a Commonwealth public servant, but what she has to say has some sway. This has not occurred now. Insurance commissions are not banned. They are still valid so long as you comply with the legislation. But that's not to say that they might not be banned in the future. But option 2, which was banning insurance commissions, has not been taken. Option 3 is to improve disclosure obligations. And option 4 is to strengthen the Office of Fair Trading's compliance and enforcement powers. And really what we have with this Act is a combination of options 3 and 4. That is increasing disclosure requirements and also the OFT compliance and enforcement powers. So what has happened here? Well, this Act basically amends 6 different pieces of legislation. It amends the Strata Schemes Management Act and Regulation. It amends the Community Land Management Act and Regulation. And it amends the Property and Stock Agents Act and Regulation. So there are 6 different pieces of legislation that are amended by this Act. This Act, the Strata Managing Agents Legislation Amendment Act, was passed on the 19th of September and assented to on the 30th of September, but it only commences when the Act is proclaimed. The Act has not yet been proclaimed, so the Act has not yet commenced. I'd expect in the next month or so that will happen, but we don't know when. I should say that in the interest of brevity, and I'm going to struggle to stay within time with this presentation, I'm not going to go through the amendments to the Community Land and Management Act and Regulation, because the amendments to those 2 acts are identical to the amendments to the Strata Schemes Management Act and Regulation. So when I go through the Strata Schemes Management Act and Regulation, those amendments apply exactly the same way to the Community Land Management Act and Regulation. Basically, the amendments can be put into 4 categories. So basically, greater disclosure obligations is the first category. The second category is putting limits on powers in terms of who can do what. The third category of these changes are strengthening the enforcement and compliance powers of the Office of Fair Trading. And the fourth category is increasing maximum penalties and penalty infringement notices. So they're the 4 categories, basically greater disclosure obligations. Secondly, providing some limitations on who can do what. Thirdly, giving the Office of Fair Trading in New South Wales greater enforcement and compliance powers. And then finally, greater maximum penalties and penalty infringement notice. So let's start with Section 57 of the Strata Schemes Management Act. Now, the thing to note here is that there is a blanket ban, prima facie, on a strata manager requesting or accepting a gift or benefit. So there's a blanket ban on strata managers requesting or accepting a gift or benefit. Now, there are under 57.3 4 exceptions to that blanket ban. So you can't, if you're a strata manager, you can't request or receive a gift unless you come within one of the 4 exceptions to that rule. The 4 exceptions are: 1, the management fee, so you get paid for the work you do. That's an exception. 2, a monetary commission that's been disclosed either in the management agreement or otherwise approved by the owners corporation. 3, a training service that is either disclosed in the management agreement or is otherwise approved by the owners corporation. And 4, a gift, so long as the gift is less than $60. So there is a blanket ban on receiving gifts or requesting gifts and benefits, but there's 4 exceptions. The first and fourth are pretty simple. The first and fourth is the remuneration for management services, and the fourth is a gift for less than $60. Those 2 are exceptions to that rule. And the other 2, which was really the thing we're going to talk about today and in various further amendments, the fact that a monetary commission is permitted if it's disclosed in the management agreement or has been otherwise approved by the OC, and a training service which has either been disclosed in the management agreement or otherwise approved by the OC. Now, that is the current law. So you'll see in this slide, current on the left side, the amendments on the right side. That's the way we will look at the changes. So I have to explain the current situation to then explain how it's been amended. The current situation is, as I said, there's a blanket ban, but there's 4 exceptions. The amendment is in relation to the monetary commission and the training service. That is, when you're approving such a monetary commission or training service, that approval or the motion to approve it needs to be accompanied by a document that details the amount of the commission, how it's calculated, the monetary value of the training, or if you don't know what it is, an estimate of that, the nature of the relationship between the Strata agent and the person providing the commission, why the commission or the training is in the owners corporation's best interest. This additional document that needs to be put to the meeting approving this commission or training service is now what's required under this new legislation. Next one. And so that's 57. Now, Section 60 is basically a strata manager must report the following at an AGM. Any commission or service received during the last 12 months and any commission or training service that is expected to be received in the next 12 months. So the current law requires a strata manager to disclose, to report at an AGM what they got in the last 12 months and what they expect to get in the next 12 months. Okay. Now, there are some additional, that's the current, there are some now additional requirements in that regard. They are that if during the preceding 12 months, a supplier of goods and services, so a gardener, a cleaner, a brokerage firm, a debt collection agency, whoever, a supplier of goods and services has become connected to the strata managing agent during the previous 12 months. What does connected mean? That's the key word. Connected is defined in Regulation 62. It basically means a common directorship between 2 companies, a common shareholding between 2 entities. So the strata managing agent might have a shareholding in a particular company. So a typical example might be you're a strata manager, your partner has a gardening service that does work for strata schemes. You as the strata manager might have shares in that gardening service business. And so you as a strata agent are connected to a supplier of goods and services. That is, you're connected to that gardening business. And if during the previous 12 months prior to the AGM, you, the strata manager, become connected, you get these shares in this business, you need to disclose that to the owners corporation at the next AGM. And that goes the same for a developer. If a developer and a strata agent are connected, that needs to be disclosed as well. The reporting requirement at the AGM also now is detailed. in the new 61D. It's set out there. Now, we also have new sections, 2A to 2D. These are not existing, but will come in. Basically, what we have is a requirement that the strata agent give written notice to the OC before entering into a contract for the purchase of goods and services if a commission or training service is going to be provided or paid to an agent, right? So before entering into a contract to buy an insurance product or a gardening service or whatever it is, before entering into that contract, the agent must give written notice to the OC if they're going to be provided with a commission or service from that service provider. And also if the agent is connected with the person who's providing that. So typically, as I said, a strata managing agent might have a brokerage firm that is a separate legal entity, and at first glance, they might look like separate businesses, or they might have a debt recovery business, and again, that might look like a separate business. But once you do the company search, you can see these common shareholdings, and so that's the connection that has to be disclosed to owners. And the notice, the way you comply with that written notice under 2A is in 2B. It sets out that what that has to be in the notice. 2C says, so 2A is about disclosing in written notice before entering into the contract for goods and services, but it might be that you have an ongoing contract, but then all of a sudden a connection arises. The agent must give written notice to the OC as soon as possible after becoming aware of that connection arising. So 2C gives that requirement. Now, we also have section 62. Now, there is no amendment to section 62, but it's actually quite an important section. So I think it's important that people are aware of it, even though there's no change to it. Where it becomes clear that the commission you receive or the training service you receive differs from what you initially disclosed to the owner's corporation, where what you disclosed would be the commission or the training service, then differs from what you actually get, the strata managing agent must disclose the variation and then give an explanation for the variation as soon as practical. So that's required. Now, with 71 of the Strata Schemes Management Act, where a person appointed as the agent has an interest, that interest must be disclosed. Now, the interest that must be disclosed currently are detailed in 71(2). This is on the left. So if the agent has a connection with the developer, that is an interest that needs to be disclosed. If an agent has a pecuniary interest in the strata scheme, that needs to be disclosed. So before you're being appointed as the strata agent, if your partner's gardening business is doing work for that owner's corporation that you're looking to be appointed for, you need to disclose that fact so that the owner's corporation knows that your partner's gardening business already does work for the owner's corporation. That's the current law. The amendment, in addition to that, is basically a person that strata manager has to disclose to the owner's corporation the gardening business that does work for other schemes in the portfolio managed by you. So your partner's gardening business does gardening work for other schemes that you manage, and then you need to disclose that fact, even if that gardening business doesn't do work for the owner's corporation that you're looking to manage. It's just so that the owners know what interests you have in other places, so that if that gardening business pops up as an option for this OC, they know that the agent has a connection to that gardening business, right? And then on top of that, if you as the strata manager have given informal or formal advice to a developer of the owner's corporation, either for that building or for another building that developer did, the strata manager needs to disclose that relationship to the owner's corporation as well before their appointment. So any of these kind of just developer relationships that strata managers have, strata managers can assist developers in finalising the development by planning the levies and arranging the first AGM and doing the various things that are required to be done at the start of the strata scheme. Any of these sorts of services that a strata manager has provided to a developer must be disclosed to the owner's corporation prior to appointment. Now, Section 166, basically there's a basic requirement that the strata manager must provide not less than 3 quotations for each type of insurance. And then what we have in 166(2) and 3, which are new, further detail is required as to the breakdown of the cost, right? So there's no kind of lump sum that can be put forward now. You need to give these breakdowns. And this information needs to be given as soon as practical to enable, this is 3, as soon as practical to enable the OC to make a decision about insurance. You can't kind of sit on it for a while there. So timing is important. Category 2 is the limitation provisions. Schedule 1 of the Strata Schemes Management Act sets out meeting procedures for owners corporations. I apologise. It says at the top there, current clause 24(7). That should read clause 25. We're talking about clause 25. Clause 25 deals with the rights of proxies and limits in the way proxy votes can be exercised. There is a slight amendment to that. So where a proxy vote is being exercised in relation to a monetary commission or training service, that is the 57(3), that should be 57(3)(b) and C, where a proxy vote is being exercised in relation to approving that monetary commission or training service, there's some limits on how the proxy can vote. We see Regulation 62 in relation to the Strata Schemes Management Regulation. This is the meaning of a connected person. But what we have is an amendment to that where if one of the persons is a trustee of a trust, they're just looking to make sure that that particular connection is included in the definition of connected persons. Yep. Now, Section 55. So this is the Property and Stock Agents Act. Basically, the Property and Stock Agents Act does many things, but one of the things it does is it sets out what needs to be in an agency agreement, and this applies equally to strata managers. And so basically, a licensee is not entitled to a commission unless you're complying with the requirements of an agency act under an agency agreement under the Property and Stock Agents Act. Now, there's a new provision there that basically says that a licensee, the strata agent, can't require a person to pay a commission in accordance with the prohibited provision. And so there are various things that are prohibited provisions. So it's basically blocking the ability of a strata agent to recover a commission in particular circumstances. And this is kind of flowing on from that. This is Schedule 12 of the Property and Stock Agents Regulation. So Schedule 12 sets out the terms that need to go into an agency agreement. There's a new Clause 6, and there are some prohibitions in terms of an agency agreement with a strata manager must not contain a provision that requires a person to pay a commission. And so again, there's a limitation there on what can be put in a management agreement. Now, we're on to Category 3. Category 3, as I said, is basically more powers to the Office of Fair Trading to ensure compliance and enforcement. The current position for Section 60, subsection 3, is basically if an agent has not disclosed a commission or trading service in accordance with Section 60, so if there's a failure of the strata agent to properly disclose a commission, NCAT can, on application by the owner's corporation, order the strata agent to pay to the owner's corporation the commission that that agent received. So if there's been a failure to disclose the commission, they've received the commission, NCAT can order that that commission be paid by the agent to the owner's corporation. That's the existing provision. The new provision is basically giving the Office of Fair Trading the power to make an application in addition to the OC's ability to make that application. So the Office of Fair Trading can actually make an application to NCAT seeking an order that NCAT order the agent to pay the owner's corporation the commission received. Section 38 and sections 53A to E, they set out a regime of undertakings by licensees. So basically, the Office of Fair Trading can accept a written undertaking from a strata manager as to how the manager will exercise their functions. It's basically designed to deal with naughty agents. So they've done something not sufficiently serious for them to be struck off, but the Office of Fair Trading wants to keep an eye on them, wants to make sure they do the right thing. So the Office of Fair Trading can receive an undertaking by a licensee that it won't do things in the future, it will do other things in the future. So various things can be extracted from agents to keep them on a short leash. Now, what we have is sections 38 and 53A to E have been deleted and replaced with a new section 210 capital A. The new 210 capital A is not referred to in the second reading speech or in the debate. So exactly what the intention of the Parliament was here is a bit unclear, but I presume that it's designed to just give the Office of Fair Trading a better instrument by which they can manage naughty strata managing agents. And it's quite a lengthy provision. That brings us to category 4, which is the final category, and that is simply the category dealing with penalties. There, as you will see, there's many pages to this. Be assured that the penalties have increased. Some penalties have doubled. Some penalties are now times 10. So there's been a very significant increase in the penalties for failing to disclose and so forth. And so that's something to be aware of.
Will other states introduce similar changes, and when?
It's a bit of a crystal ball exercise. This is New South Wales legislation. It's very clear from the debate that more may come and probably will come. So other states might look to see how this plays out in New South Wales before actually moving. And I mean, we're in late October now, so I can't see any further amendments this year. This McGrath-Nicol report's got to be handed down. So if there are more changes, it will be next year. So I think other states and territories, if they're going to follow, will probably want to see how this plays out before kind of slavishly copying this particular piece of legislation.
To the extent that some or bigger strata firms regard penalties, if brought to bear, are a cost of business, do you believe the higher amended penalties are sufficiently onerous as to encourage more compliance?
Well, the penalties are now going to run into the thousands of dollars. So I'd expect, and as I said, some of them are doubled, but some of them are now times 10. So any of that kind of cost of business argument, I think this isn't $500 anymore, you know. So I think that starts to fall away, I would have thought.
Okay. And what detail has to be provided in a quote for strata building insurance as to the breakup of the costs and commissions and fees?
So the new section 166(2), not in force yet, but in the next month or two, that requires a breakdown of charges for insurance quotes. So the breakdown is that base premium amount other than commission. 2, commission other than brokerage fee expressed as an amount and as a percentage of the base premium amount. 3, brokerage fee expressed as an amount and a percentage of the base premium amount. 4, stamp duty. 5, levy amounts. 6, underwriting agency fees. 7, GST. And 8, other amounts or percentages relating to the charges prescribed by the regulations. So that's the breakdown for insurance costs that will need to be provided with a quotation now. So that's every possible detail you could ever wish for, I would have thought.
Okay, and also I'm under the impression that our strata management company pays its strata managers a commission for extra hours they bill the body corporate. This has never been disclosed to us. One manager billed us for many activities that had previously not been charged, and the company did not resolve these issues but replaced the manager only after we threatened to move to a new strata company. Under the new legislation, a strata company is required to disclose commissions paid to employees.
Well, that's not a commission to the agent as such. The agent is receiving the management fees presumably in accordance with the agency agreement. And so if there are Schedule B fees to be paid, they are paid to the agent, and there's no issue with that. That comes under the first exception to the blanket ban against gifts or benefits. And then how internally a management firm deals with those Schedule B fees is really a matter for the company. Now, you might argue that there's an incentive for strata managers to bill Schedule B fees, but there is obviously the thing of they can't just be charging for nothing. There has to be some monitoring and approval process involved in those sort of variation claims, as it were. But the internal process of distributing fees to managers, I don't think is problematic.
And does the new legislation that's coming out, does it mention anything about the disclosure of those Schedule B fees and what they're for? No. Okay. Will NCAT work closely with Fair Trading enforcing the penalty when a strata manager's license has been cancelled?
Well, I would expect they would. I mean, the penalty, to be clear, the penalty doesn't go to the owner's corporation. It goes into consolidated revenue for New South Wales government, and they will recover those penalties as a matter of course. They wouldn't do it with alacrity, but they'll get there eventually.
Thank you so much. We thank everyone for joining us. That was a really great overview of all of the changes that are coming. So we really appreciate that you went into so much detail with the legislation changes and provided that information for our viewers today. As you said, they can go back and have a look at the presentation recording and also go through your slide pack and sort of take it one by one, and that will give them a guidance of what changes are coming up. And we'll keep everyone informed as soon as we hear anything regarding when the new laws are actually coming in.
Indeed. I'm thinking in the next month or two for this act. So it may be that it's piecemeal, that it's in parts, some parts this year, other parts next year. I just don't know at the moment. It comes out with the Government Gazette. They don't give you warning. It just, boom, proclaimed. Oh, okay.
Wonderful. So everyone else will know when we know. And I think there was one question about whether it will be retrospective, and that's something that we didn't talk about. Okay, so they will give a date and it will be from that date moving forward.
Correct.
Yeah, yep. Okay, wonderful. All right, well, wonderful. Thank you so much. Thanks, everyone, for joining us. Great to have you in here and in chat. Thank you for contributing to the chat and the conversation. And Chris, we thank you very much for joining us again, and we look forward to chatting to you next time.
Okay, thanks, Nikki.
Wonderful. Thanks so much.
Cheers.
Bye.
Bye.
If you gained value from this video, please hit like and subscribe to our YouTube channel. If you're looking for information about parking, strata insurance, defects and more, head over to lookupstrata.com.au or sign up to our free weekly newsletter via the link in the description box below.